and welcome members. As everyone else is joining, I would just like to recognize our VP, Dr. Ibrahim Matende, who's on the call as well. And thank you very much, Catherine Kariuki from Africa Privacy and Legal Partners. We welcome you and thank you so much for being able to facilitate this very important session we're having today evening for KMA members. So kindly share the link with a colleague, kindly share it in your groups as we wait for the rest to join in. Just a little housekeeping, kindly post your questions on the Q&A section and let's reserve the chat for general comments. Peter, I hope we have the Q&A enabled so that we're able to track the questions and it's easy for Catherine and team to do so. Then the recording will be available on the KMA platforms, that is throughout, and our YouTube page where we usually upload all the webinars. So you can reach that there as well, and this will be sent on email to those who've registered. So karibuni sana, even as we look at compliance with the ODPC and gain insights. KMA is also looking into being able to partner with some of these firms to assist the membership in getting compliant. So welcome to today's evening webinar. Kindly share with a friend. Dr. Matende, are you in a position to say something before I can invite our speaker for today evening? Okay, so I guess we'll allow Dr. Matende to speak a little later. Allow me to invite Catherine Kariuki, who's a partner at Africa Privacy and Legal Firm, and I'll allow her to introduce herself further and just get into today's program. Catherine, karibu. The floor is yours.
Thank you very much, Dr. Brenda. I'd like you to just confirm that you can see something on your screens.
Yes, we can.
Perfect. All right. So I'll start by introducing myself. As Dr. Brenda has said, I am Catherine Kariuki Mulika, and I am a partner at Africa Privacy and Legal. Africa Privacy and Legal is a specialist firm that deals with all matters tech, data protection, privacy, intellectual property, and fintech. So personally, I have worked over 15 years in this sector. So basically what I do is I support both startups and scale-ups to just as they digitize and as they come up with issues to just make sure that they're compliant and so that to remove the compliance headache so that they worry about the business aspect of things. And I'm sure you agree, like this is an area where you need like specialists, and that's why we ended up like specializing in this space. So we provide both technical and legal support. Within our teams, we have technical experts, IT experts, because the two fuse together. And we'll be learning more about what we do at Africa Privacy as we go along. But so today's session is, we were invited by Dr. Brenda and team to just take you through the data protection basics. And that's because, I mean, as much this data protection and privacy subject is it's very deep and intertwined with so many things within the business, but you have to start from somewhere. Unfortunately, you can't start from the very end. You have to start from the beginning and then you work your way on other levels, on advanced levels. And there's only so much that I can cover tonight or within an hour, but at least at the end of this session, I'd like that those who participate in the webinar are able to at least sustain a conversation on data protection and privacy and link it with what they do, you know, as a practitioner within your practice or in your day-to-day work. Like by the time we're done, at least you should have a rough idea of how it impacts what you do and what is expected of you as a practitioner when it comes to the ODPC, and have a rough idea even what the ODPC is about. So if we go to the root of data protection, really, I'm sure if you've been in Kenya, you've definitely had people throwing around the word, you know, privacy, data protection. That's because in the constitution that we have, the 2010 constitution, we had every Kenyan citizen was guaranteed the right to privacy, and that's Article 31. So then within the constitution, Parliament later on came and wanted to expand that privacy, because if I ask 3 people today, what is privacy? And if you can interpret privacy within the context of what you do, those 3 people will probably give me 3 different interpretations. So over time, there was need basically to at least have a set of rules or guidelines to guide people. This was around the same time that, you know, the social media companies were coming around and collecting copious amounts of data, citizens' data, and they were doing all these kind of things in the back end regarding this data, where they could probably even tell you more about yourself than you knew. You know, by putting this data together and doing all these things in the back end, they'd be able to actually like track your whereabouts, track your personality, be able to tell you, you know, this is this one's mother. I'm sure you heard of periods where there were all these digital lenders that came around that would use a different social scoring mechanism to be able to know whether someone was a reliable or credible when it comes to repayment or not. So around this time, what happened is there was a global wave, right? There was a global wave of where consumer protection activists started pushing for data rights. And people, they started saying, you know, corporations are doing all these things with people's data, but why can't we put the power back in people's hands? So what happened is now countries started saying, okay, we need to protect our citizens' data as far as these corporations are concerned. You know, some corporations were global, Google, Facebook, and everyone. So people started going back into their parliaments and their countries and enacting laws that protected their citizens' data so that these corporations were limited on what they can and can't do. Then there was now this global wave, and this is around the same time, around 2015, 2016, when we had what we call the EU GDPR. EU GDPR is the European countries via the European Union. They came together and they enacted this data protection law that is called EU GDPR. The implications of that law was that all their trading partners that would trade with Europe were now told, you know what, you can't trade with us if you don't have data protection laws in your country. Because of such pressure, what most African countries did is they ran back to their countries and just borrowed heavily from this EU GDPR and enacted laws within their country. This is around the same time that 2019, our parliament went back and enacted this law that we call the Data Protection Act. Around the same time, you'll find there are so many African countries that ended up enacting their own data protection laws around the same time. The common thing about all these data protection laws is that they really mirror that law that I've explained called the EU GDPR, right? So then what happens is if you are compliant with the Kenyan Data Protection Act, you are to some extent compliant with EU GDPR. EU GDPR is very expansive. And what the African countries like Kenya did, they went and picked aspects to also suit the Kenyan market, they didn't pick the whole EU GDPR and enact it. They picked aspects, although these aspects mirror EU GDPR widely. So that what that means is that if you have, let's say, data subjects, or you process data that relates to foreigners, you'll find that what is required of you when it comes to EU GDPR is almost the same thing that's required of you in Kenya. So I'm giving that context to just understand the background of where these data protection laws came from and why there was suddenly a wave and everybody is talking about data rights and privacy. So now we can get into the talk with that background. I've already explained what I do. I'm a specialist in this area, and those are some of the people that I've worked with. I've worked with both what we call startups and scale-ups. And why I work with all the people along the chain is because really the issues are the same. The scale is what is different. The risk is what is different, but it's usually the same thing. So now getting to it, the Data Protection Act, which was enacted in 2019, there were several bills that had come, had been brought before Parliament, but they hadn't made it through until this one that was brought in 2019. So this act, the Data Protection Act, it applies to Kenyan, the data, let me start by saying it's a consumer, it protects consumers or data subjects. So it faces that side. It comes from a consumer protection angle. So the people it protects is the people who own this data, the people whose data you process or handle, and they're called the data subjects. So the scope, the people who are covered are, as long as someone is resident in Kenya and you handle their data, then you're expected to handle their data in accordance to the Data Protection Act. Note that I didn't say a citizen, I said residents. Residence is because you can be American, but you're in Kenya, and you come and see a doctor, and a doctor handles your personal data. Your data is supposed to be processed in accordance with the Data Protection Act. The other catch is that it only covers data of natural persons. For those who are not clear about this, so there is natural persons and there's legal persons. So a company, for example, a limited liability company is considered a person, but the data of this company is not protected by the Data Protection Act. The scope is limited to a natural person. Data of a natural person. So I want you to have that in mind. So for example, you can have what? Your suppliers. You can have a supplier company's details and you process their data. The scope doesn't expand to that. But if you have this supplier of yours is a natural person, then the scope extends to them. So as long as it's a natural person, then you know that the scope extends to them. This is usually important when you're segregating data and deciding how to handle certain data. All right. So for today's session, I'd like you to walk away with the knowledge of certain terminologies. If by the end of this webinar, we have understood these terminologies, then it's a good start to the next, say, session or the next steps that we take. And these are important because they form the foundation of your understanding of why this law is there and what it means and what implications it has on your processes or your business. So the first thing is data. It looks like a very not clever thing to do to explain data because someone would be like, oh, that's obvious, but not really. But let's just define it. It's information processed by means of equipment as duly instructed. So information, don't overthink it. As long as you have information in whatever format, it doesn't matter, then that's data. And therefore, you're brought under the scope of the Data Protection Act. Then there's what we call a data controller. This act separates two kinds of people handling people's data. So you can either be classified as a data controller or a data processor, right? And in most instances, almost everyone who runs a business ends up being both. You can be mainly a data controller, but there are some aspects where you're a data processor. And I'll explain why. So the data controller is the one who determines the purpose and means of processing the data. What this means is that the data controller, you're the one who collects directly from the data subject, or you're the one who gives instructions and tells, for instance, when you put a soldier or a receptionist, right? Or a watchman, and you tell the watchman that everybody who comes into this building, I want them to sign in that book, yeah? Collect that information for me. You see, you're the one who determines the purpose and the means of processing that data. You are the data controller. That person is collecting that data on your behalf. Now, who is a data processor? That watchman, let's say if you use G4S, G4S will call themselves a data processor because they collect the information on your behalf. Now, why I'm saying that most of the times you'll end up finding yourself being both with one primary one is because there are instances where you will collect certain data on behalf of someone else. You're collecting it to transmit it to someone else. And in that instance, you'll be a data processor. Well, there are instances where you directly collect the information yourself, or you ask someone to collect it on your or process it on your behalf. In that instance, you'll be a data controller. I hope that I've tried to make it as basic as possible, and I hope it rings home because that's very important. When you're categorizing your data, you'll need to ask yourself, in this instance, am I a data processor or a data controller? And the reason why you'll be asking yourself these questions is because the responsibilities that are accrue by virtue of being either a processor or a controller are very different. Different in the sense that the one who has the primary responsibility is a controller. So the moment you find yourself being a controller, your obligations are more and your risk is higher than a processor. A processor still has some risk, but not as high as a controller. I mean, to state the obvious, most practitioners or business owners end up being data controllers, especially in the field of health. If you have a health facility or a clinic or something to that effect, and where you see clients directly, your patients, most likely you're a data controller, but there are aspects where you would also end up being a processor. The next one is the identifiable natural person, which I mentioned earlier, the differentiation between a legal person and a natural person. Natural person is what I explained, binadamu, and identifiable natural persons means someone that I can tell or explain clearly. It can be, and this the identifiers, what we call the identifiers, are just not your name. It doesn't mean that it has to be Mary Wangoi for me to say, oh yeah, Mary Wangoi is an identifiable natural person. Sometimes it's Mary Wangoi's ID number, so that if I take her ID number and I combine it with something else, I'm able to tell that it's Mary Wangoi. So this identifiable natural person could be identified using an ID number, a location data, online identifiers. It could be the physical address, physiological features, genetics, records. As doctors, all those records that you hold, which if I put together, I'd be able to come to the conclusion that this is Mary Wamboi. And that's what we call personal information. We'll go deeper into exactly what are the categories of personal information, to what extent they go to. Next is data subject. Data subject I've explained to you earlier, but I'll touch on it again because if not anything else, you need to understand this very clearly on who is a data subject. When you're talking about this is a data subject, my patients are data subjects, or the people that I serve are data subjects, or my employees are data subjects. So this is an identified or identifiable natural persons who are subject of personal data. So I want you to think of this in the context of your business, however your business is structured. If you process a payroll, So as far as your employees are concerned, they are data subjects because you process their personal information to some aspect. And of course, there is a patient. If you handle patient data, those are data subjects. So they're the people who own that information that you're processing, right? When it comes to personal data, again, it's information related to that data subject. Who, remember we said that data subject is an identifiable natural person, right? Okay. When it comes to personal information, which I've just explained, which is personal information that you're holding relating to a data subject, it's divided into two. And why it's divided into two is because one category has a higher threshold when it comes to responsibility. When it comes to the health sector, it falls under this category called sensitive data. So there are few industries that fall into this category. So financial services sector also fall into this category. And by the reading of the act, you can tell that the categorization was based on risk of this particular data being in the hands of the wrong people. The data subjects would face a higher risk, whether it's identity theft, whether it's privacy breach, when people's medical status is known. So these industries, they usually categorize as sensitive data, as having handled sensitive data, and they're subjected to a higher threshold. Being subjected to a higher threshold is things like they're told they need they cannot get away with just doing the basics. So when it comes to like cybersecurity, they need to demonstrate that for real, they have really enacted quite tight cybersecurity measures. And therefore, if a data breach occurred, it would be what we call an accidental data breach and not one out of negligence. So if anyone handles this kind of data, just know it's sensitive data. Health, which I said, it's obvious. Like, don't even start thinking if you're categorizing. If you're in the health sector, don't start even thinking, oh, am I in the sensitive category or general category? You're definitely in the sensitive category. So there's health data. There's data to do with ethnicity, conscience and belief, genetics, biometrics, property details. There's marital status, family details, sexual orientation, race. So if you collect this data, for instance, if you have a form where you ask someone, oh, do you have, write down the conditions that you have, or are you, this is not common in Kenya, but I know it's common out there. It happens out there where people ask for what's your ethnicity or what's your race. In Kenya, obviously, if you asked what's your tribe, you would be collecting that. What's your political belief? If you use like some sort of like biometric identification, if you ask for, interestingly, it's been held that if you ask for address, what's your physical address, that's property details. Like if you ask someone to say where they live, that's property details. Marital status, where you say, are you single or married? Family details, where you say, are you married? List your family dependents or your next of kin. That's family details. Sexual orientation, which is obvious, and race, as I mentioned. These others are now categorized as general. And I said the only difference is that there's a higher threshold when it comes to sensitive data. So these general ones are the usual ones which almost everyone collects because, again, they're usually necessary for you. If you're going to do the business with that person or the function that that person is hiring you to do, most of the times you will need to collect this, which is name, work-related circumstances, date of birth, phone number, IP address, postal address, personal finance, email address, all those things. Continuing with the terminologies, by the time we leave, I need you to have understood what processing is. Because I have kept on saying, oh, if you collect data, if you process data subjects information, so what is processing? Processing is anything you do. Let me just say anything you do with any data you collect. The moment I put down my data, to you, you give me a form and I put my name. It doesn't matter what you do. As long as you've collected, yeah, that is processing. So it expands to people who might say, oh, but all I do is storage and everything. So as long as you collect, store, share, modification, or delete, that's processing. So the general word that's used is processing, right? Then we go to consent. This term, I'm sure you've heard it being thrown around. Oh, and some people flexing. Do you have consent? I will not give you consent. But in the medical space, I don't think consent is a new term because most people the medical field has always relied on consent from patients in certain instances. But within the data protection space, consent is one of the reasons that you can use to process a patient's or a data, let me use data subject data. Note that I've said because one of the things that people confuse, and I want you to walk away from here knowing that consent is not the only thing that you need as a justification for processing someone's personal information. There are many justifications that you can use, but why consent is common is because it's the clearest. It's black and white. If someone has given you consent, which is permission, it's black and white. I mean, if they start saying, oh, I didn't, you produce the consent and you say, but they gave me consent. But it's not the only reasons. There are other reasons. And even as practitioners, I'm sure you're aware that there are situations, especially in the medical space, in case of emergencies, I don't need to have consent from you to operate on you. And there are also some justifications. The Data Protection Act is not unreasonable. There's some justifications that it allows for carrying out business, but within reasonableness, to also remove the cumbersomeness that would be brought about that every time you need to do something with my data, you come running to me with a consent form. It's also anti what they're trying to advance, because again, you're going back to disturb the data subject. So this consent is, yes, it carries a lot of weight, but it's not the only thing, and it shouldn't be a bottleneck for anyone's business or for anyone's operations. That's one thing that I want you to walk away with, at least when you're dealing with the issue of consent. However, what it means is you need to sit down and weigh what are the 3, 4 things or 5 things that within my clinic or within my operations, I need to seek for consent. And then these 5, 6, 7 things, these are the justifications that I have. And that's why I don't go to seek consent. The other terminology I want you to walk away with is data breach. I'm sure you've heard about, again, we live in a digital world where there's a lot of, it transcends physical or geographical boundaries when it comes to cyber criminals, and, we'll keep hearing of a data breach here, a data breach where, and these cyber criminals are always hitting data heavy, people who have huge volumes of data out there. We know like people like banks, especially, are usually targets, and even health institutions because of the weight, again, and the sensitivity of the data. And why these entities are targets is because the cyber criminals are more likely to make money from their attacks by doing whatever they do so that they are paid by those people so that they don't release that data. So that just means in terms of risk, the risk is usually higher for people who process this sensitive information. So in the context of data breach, I want you to walk away with this. The regulators never look at data breach, that no one should ever suffer a data breach, right? Why? Because in the context of the digital world, there's hardly anything that you can do that's 100% proof in terms of that you cannot be hacked or that you cannot be subjected to a data breach, that your files cannot be stolen. The attitude of the regulators is always It's not a matter of, if you will suffer a data breach, it's a matter of when. But the regulator says, if you're going to suffer a data breach, it better not be what we call a negligent breach. It better be what we call an accidental breach. An accidental breach means you've put in all the measures necessary. You've done the best that you could to secure the data subject's data, but these cyber criminals or these whatever people have gone above and innovated new ways of carrying out their cyber crimes, and therefore you have suffered a data breach. So the regulator doesn't tend to punish all data breaches on the face of it. What they do is they punish people who have suffered what we call negligent breaches. And what we call negligent breaches, part of what they look at is even, okay, you were hacked. After you were hacked, what did you do to mitigate exposure of your data subjects' data? For instance, did you make phone calls? If you knew that, for instance, me, Catherine, your patient, and that you've been hacked, or let's not even say hacking, like someone entered your office and stole my file with my records, what did you do? To what extent did you go to just secure the same? Let's say if it has my credit card details, did you call me and tell me, Catherine, you need to stop your credit card, you need to call your bank and stop your credit card because there are people who've broken into the office and they have accessed the same. And also part of what the regulator usually expects is for you to file a report with them and tell them we've been hacked or someone came and stole files from here, but this is what we've done to mitigate it. I want you to walk away with that because for a business, some of us even probably suffer data breaches that we have no idea about. Your employee walks out of your office with a file to go and work from home. And maybe in the matatu, they lose a page of that file. And that file happens to have a list of, I don't know, patient's data or whatever it is. That's a data breach. But then a data breach doesn't have to occasion a loss or that the person on the other side does anything about it. A missing file or someone who walks away with, they hacked and they walked away with the data, whether they did anything or not is irrelevant. That's a data breach in itself, okay? And it has responsibility when it comes to your regulator, especially now that you're registered with the regulator, it has responsibilities. Let's talk about the other term that I want you to be familiar with, which is data minimization. We'll look at this when we're looking at the principles, but let me just cover it. It's because this principle requires you to only collect what is necessary. We're coming from an era where people used to just ask for information just in case. Like you'd give me a form and you'd ask for all kind of information. Who's your mother? Who's your father? Where do you live? But what this does in the data protection realm, the data minimization principle requires you to think about and only collect that which you need. So that means you have to go through your information and ask yourself, why do we collect this, by the way? And do we actually even need it? And write down a justification of why you collect what, so that if anyone ever came asking, you'd be like, yes, we collect just the absolute necessary information. We don't collect anything that we don't need for just in case. There's also purpose limitation. Why I want you to understand purpose limitation is because in the Kenyan scenario, it's very common for instance, for me to come to your office and then the soldier tells me at the gate, everybody who comes into this building must leave their information with us. So then I leave my information. And then the next day, someone from your office calls me and says, oh, incidentally, we're selling this. You came to our office yesterday and now incidentally, we're selling this product. We'd like to know if you're interested. Or you start now spamming me with details. To even give it so that's a simplified example. To give you the context of a doctor is you collect my information and then tomorrow you partner, say, with someone who sells certain drugs and because I have that condition, you start sending me emails to market those drugs to me. That's not allowed. And the people that you've seen get into problems with the ODPC, this is one of the things that gets them into problems, that you picked my information for A, and now you're using it for B. You didn't tell me that you're going to use it for marketing, and now you're marketing to me. Then I go and report you to the ODPC. Then the ODPC tells you, why are you using this information for B while you collected it for A, and you get a fine. Yeah. All right. As I said, as I'm explaining these terminologies, I want you to think about them in the context of what you do daily. And because all businesses are not the same, everyone's business is different. So put it in your context and ask yourself how this affects you. Then there is confidentiality, which is not new to the medical fraternity. Even the legal fraternity, we've always have the concept of confidentiality. And obviously this is the duty to keep the patient information private and only share it when it's necessary and lawful. This has always applied in the context of if I'm your patient and then tomorrow someone comes and says they are my sister or my brother and they'd like to access, my personal information, how do you go about it? Or do you just release the information to them? When you're sharing information with insurance companies, to what extent should you share my personal information, and what consent should you make sure it's there so that I have consented to you releasing certain information to the insurance company, to a larger hospital, to another consultant? Because I've seen scenarios where I, as a patient, will probably see 3-4 consultants, but it's interconnected, and the various consultants will probably need to access one set of data held by one healthcare provider. So how do you go about that to make sure that this person won't come later and say that you breached the duty of confidentiality? There's data retention. Data retention just has to do with how long can you keep patient data. Can you keep my patient data from 1989? And for industries like health, even as lawyers, you don't have to overthink this one, because most of us have good reasons to keep data for long. And if not, then you'll have justifications for keeping patient data for a certain period, because it's one of those industries where you probably need historical data to treat a patient, so you can keep as long. So this one, I wouldn't worry about it. But remember, again, you also have data of employees, because especially if you employ people. So how long do you keep employee data? There are laws around how long you should keep your tax data, which I'm sure maybe your accountant would have told you. There are laws about how long you can keep your employees' data under the Employment Act. And that's what you should concern yourself about more than the patient data, because the patient data, as I said, there's usually a justification to keep it for a long. You just need to say, my policy is to keep patient data, for instance, for, 15 years, and then archive it after that. It depends on your individual policy, whether you're a clinic, a solo practitioner, a hospital, so it's different. Access control. Why I want you to fundamentally understand this concept is because, remember I talked about negligence. You can't be negligent in who can access what in your office. Just because you have a clinic, it doesn't mean that even your cleaner can have access to the files that you have. You have to have, whoever has access to certain data, you have to have a justification on why you're allowing them to have it. I'll give you an example. An organization like Safaricom is always before being taken to the ODPC, and it's usually taken to the ODPC because it will be that their customer care agent, a rogue customer care agent, accessed certain information like my M-Pesa information or my M-Pesa statement and give it to someone else unauthorized outside. And why a company like that usually gets away with it, it's because they usually go and demonstrate that this customer care agent, for them to be able to offer that service to the customers, they need access to this M-Pesa statement. And therefore, they convert it and now say this was a rogue employee who we've reported to the police about. And on that basis, they're usually let go. However, if these employees say had access to data that has nothing to do with his job description, that organization would really get into problems. So within the context, say, of a medical practitioner, if a cleaner, for instance, is able to get an Excel sheet of all the patients that the doctor has, every file that has been opened, what's your justification for not having controls on who can access what? That would get the particular practitioner or facility into problems, a lot of problems. So think of restrictions of what level, who can access what, and if possible, break them into small parts so that even if you got a rogue employee or a rogue player within your practice, they can only walk away with certain data, but not everything. No one should be able to access everything because that's very, very risky for your business. Let's talk about a DPIA. This is a data protection impact assessment. Although the name sounds very technical, don't overthink it. It's just a risk assessment. This is usually a requirement by the ODPC that you need to carry out a risk assessment before you handle sensitive patients' data. So all it's telling you is usually sit down. It's usually a document where you feed in what kind of data you collect and why, and then you ask yourself, which is the riskiest data that I have? Where do I store this data and what are the risks I face? The risk I face is, for example, if someone came and walked away with this Excel sheet, and then now I'll come and fill there, then what should I do to just make sure that I have a lower risk level so that no one is able to access this? And it's a simple things like password protected computers, having filing cabinets that are locked up, so that you'd need a key to access them. Not having that book that people put there for the soldier to sign, because if someone walked away with that book, then you can imagine the kind of information that they would have to access. Maybe have them have a sheet for the day only, or even better, if they can fit in the information into a tablet. It's just those things, but that's what a DPIA is. It just means you're being forced to sit down and ask yourself, what is the risk I face as a practitioner? Then let's talk about anonymization and pseudonymization. Again, even these ones, don't overthink them. They sound like technical terms, but it's one of the things that I usually use to now mitigate the risk of what I'm telling you. Like, yes, okay, hold all this data, but what can I do so that I reduce the risk of this data being identified to the particular data subject, or if this data was accessed by someone, then how do I reduce the risk of my data subjects being exposed? So then there's a data localization. Why I brought up data localization is because it affects the health sector in a big way. The local laws require that sensitive data, if you're handling sensitive data like health data, then the data has to be stored within Kenya. And what they do is they go ahead to say, if you're going to transfer it outside Kenya, then there are certain measures that you need to take before transferring. Mark you transferring in the context of data protection. Don't think physical or using a plane or DHL. Transferring sometimes is just sending an email to someone in another jurisdiction and it's considered data transfer. Or sharing a Google Drive with someone who's outside the country. It's quite technical, but we can get into it should you want. There's third-party sharing. I bring up third-party sharing because in the medical facility, as I'd intimated before, I know there's a lot of probably sharing of data to treat a patient. It will be an insurance company, a research institution, a lab. All you're being asked is this third-party sharing. A third party is someone else apart from you and that data subject. So someone else. So if you're sharing with someone else, there's some things that are required for you, some safeguards that you're expected to put in place before this sharing. Remember, this Data Protection Act by the doesn't say, there's nowhere where you'll find it saying that you cannot. What it will do, it will say that if you want to do X, then you need to meet this particular requirement. Because as I said before, it's not there as a bottleneck carrying out business or operations. It just requires certain safeguards before you do so. Data encryption, again, that's another technical term, but it's just securing electronic patient data so that unauthorized readers cannot read it. They'd have to decrypt it. So it's one of those technical things that your IT guys would be able to do, especially where you hold data in digital format. Multi-factor authentication, I'm sure you're familiar with this, especially those who have phones. It's just that it's a situation where there are tiered levels of access to the information. For instance, for you to access the information, a text is sent to your phone. There are many, many, many ways, tiered ways before you're able to access the information. And of course, it just makes it a bit harder for those outsiders to be able to access that data subject's data, and in the process you're able to take care of potential data breaches. So let's talk about an incident response plan. An incident response plan, think of an incident in the concept of something has happened. It's exactly that, like it's that basic English. Something has happened in the context of the data that you hold, the data subject's data that you hold. Something has happened. So this plan just thinks of what will be done when that thing happens before it happens. So it just requires you come up with a plan so that, remember I said, like a data breach is not a matter of if, it's a matter of when will you suffer that data breach. So it's saying prepare in advance, have a protocol, have a laid down procedure so that remember, you probably won't even be the first to know that a file disappeared. Maybe it will be your secretary, but part of the incident response plan will probably be to train. You've trained your secretary so that if she notices that a file is missing, what does she start in motion? She comes, she reports, and then who does what. Most places usually have a centralized person who is called a DPO, and it doesn't have to be sometimes it's someone with another job role, and they also add up as a DPO. And this person, everyone is trained that if you notice there's anything off, as far as data protection is concerned, maybe a missing file or a hack or something like that, go report to so-and-so so that they initiate what we call the incident response plan. Then there's the electronic health records. Why I brought this up is because in this day and age, I think most practitioners are moving to digital records of patients and health information. So then you have to think of digital ways of securing storage and, of course, access control. Obviously, the easiest thing for cyber criminals to access is this digital records, yet there are also benefits. It's a double-edged sword in terms of there are also benefits of digitizing your operations. There's the efficiencies that come with it, but there's also the potential risk that comes with it, which is this. The other thing I want you to mark is the audit logs. Audit logs are records of basically who access patient data. Think simple things like before, like places that have physical data, they usually have say like biometric that will show me who entered at what point, who took what, or even the simple things like someone will write down who entered at what time and what did they take, what did they access. Sometimes if it's digital, there'll be digitized audit logs, but then if it's a folder, you're able to see who logged in, who accessed what, and what did they see. This is usually important in case of investigations, why you're doing investigations, especially where you've gotten a data breach, because you'll need to provide it. I go back to processing. Like, I want to give you practical insights into when we say you're processing data within the context of running a business, then what is it? Because don't think, like now for practitioners, you'll probably go straight ahead to just think that processing is when you collect information. But as I said, from patients, sometimes it's third parties and service providers like insurance. Sometimes it's employees. As I said, when you're recruiting, not only employees, but potential employees when you interview them. Sometimes it's regulators. Remember, there's certain data you share with KRA, NSSF, and HIF when you're paying people's dues. Sometimes it's a HR, payroll processing, as I said. Sometimes it's a CCTV. Remember, CCTV is also, you're collecting people's images and personal data when you put a CCTV recording in your places of work or in your organizations. Sometimes it's promotional marketing when you're promoting something or when you're promoting your services or your business. Sometimes it's partnerships. In the context of doctors, I said you can be 3-4 doctors treating the same patient, and therefore you need access to the same information to be able to treat. So think of that context. I mentioned principles a bit earlier for processing personal data. If you haven't been awake in this session, this is when I need you to wake up and at least know these principles, because once you understand this, then you've understood almost 60% of data protection and what is required of you as far as the law is concerned. So principles of processing, it just means these are the expectations, the minimum expectations expected of you if you're handling any personal information of any kind. The first one is lawfulness. Lawfulness just means that the information that you are processing or you collected, you got it legally. This was put in place because I'm sure you've heard of situations where, like during election periods, where people get lists unlawfully. You didn't collect from me directly as Catherine, but then I'm getting SMSs telling me, calling me by my 3 names and telling me they know I'm a voter from Dagoretti and I should vote for so and so. That's unlawful, and you can get into problems with that. This is usually mostly for people who work with third parties. If you get information from other people, you have to be very careful and find out how do they collect information so that the information that you get is lawful and no one can ever come and say you collected unlawfully. The second one is purpose limitation. Purpose limitation just means, as I've explained earlier, when you collect for A, never use that information for B. And if you need to use it for B, then you have to come back to me as Catherine, the data subject, and tell me we want to use your information for B. Can we proceed? But if in the beginning when you collected, you told me you're using it for A, then please steer clear. Otherwise, you'll get into problems. As I said, most of the people who got into problems for this are marketers, people who take information and later on you want to market things to me. The third one is storage limitation. Storage limitation, as I said, is don't keep it for longer than you need it. But as I said, I think I explained fully what you need to consider if you're in the health sector. The other one is fairness. Fairness just means when you use someone's data, just use it in a way that's fair and doesn't harm them. By this, they usually use a technical term called ensure, gauge the risk to the fundamental rights and freedoms of the data subject. And what that usually means is just don't be reckless with their data. The instances when you can use but you should be able to see, this one is too risky. This kind of data is too sensitive for me to use it in this way, then let me not. Or this will prejudice this person if I used it in this way. So for instance, like if someone's sexual orientation is, I don't know, gay or something like that, and you're using this information with such recklessness so that anyone can come across it, then that person can say, I'd be prejudiced in that situation. Let's even come down and think in the context of if someone has certain conditions like HIV, obviously you'd be expected to operate within such restraint and sensitivity when handling that person's data and give it a higher threshold of confidentiality. So that's all fairness means. And the instances where you can be said that this one, you interfered with someone's fundamental rights and freedoms, and you are quite unfair in how you handled their data. Transparency just means from the word go, tell me why you're collecting my data and what you'll do with it. That's just what it says. Otherwise, if you didn't tell me, then you didn't have permission for it. And that's why, like, most of the times you're bombarded by, like, say, like these apps. When you're signing on with apps, you're bombarded with long terms and conditions and things like that. They're attempting to tick that box of transparency. We've told them what we're going to do with data, everything, all about us and things like that. And they've ticked the box, and therefore we tick that. Otherwise, if you're told, if you didn't, you can get into problems. Then there's data minimization. Data minimization is what I told you. Don't collect all kind of data just because you may need it. No. Just collect what you need. If you need something else later, you'll go back to the data subject and collect more. Then there's upholding the right to privacy. I explained under Article 31 of the Constitution. This is usually not, this is the one that everything else, this is a mother of all things, data protection and privacy. Everyone is guaranteed the right of privacy. So what this means, it covers everything else. It's just telling you, with everything that you do with the data that you collected in mind, hold the right to privacy. So just try to demonstrate that I tried. I tried. So it's the basic things like, I'll go again to that book that when I go to receptions, I see a book. And this book, because it's usually an A4 that has 60 lines, it means 60 patients need to fill their data before the page is turned over. Which means if I just scroll and look through, I'm able to tell who was here last week, but one, and I'm able to see, you're not, that's just a basic example. You're not upholding the right to privacy. It's the small changes that would make all the difference. Every day, new page. Or if you really don't have to, you ask yourself, like, why is this book there? And does it enhance my security or not? So that's just an example. Then there's the principle of accuracy. Why this principle is there is because in the digital age, just to give you a background, in the digital age, it's the era of, the internet. There was a lot of people, say like Google, having articles where, for instance, someone was accused of, I don't know, whatever you can think. And remember, the internet is permanent, right? Whatever is there will be there tomorrow, will be there the other day. So then in the Western world, there was the issue of, if, for instance, I was acquitted, if I was tried and I was acquitted, or if went to a court of law and found out that that wasn't true, and indeed it was a defamatory statement, why is it that when someone Googles me, they still find that history? So then over time now there came these rights, digital subject a right to have their data being accurate. And therefore, what people now would do after data protection laws were enacted, they'd go back to these companies like Google, Microsoft, and tell them, you owe me, you're supposed to process my data with the principle of accuracy, and therefore I need you to delete this. In the banking sector, what used to happen is, let's say like for loan processing, they would process using inaccurate data, and I would be denied a loan, and the companies wouldn't care about correcting this data. So in this day and age, what people do is you go and you tell them you're supposed to operate within the principle of accuracy, and therefore change my data to correct it. Right? Up to there, I hope we're together. And Dr. Brenda, tell me when you need us to take a break, if at all. So let's move to lawful basis. Lawful basis just means, okay. Again, I said the act will never stop you from collecting whatever information you feel you need, right? But you need a lawful reason for processing personal data. If you remember when we started, I said, yes, consent, muhimu sana, but is it the only thing that you can rely on? No, because if consent was the only thing that businesses and institutions had to rely on, it would be so cumbersome and nothing would ever move in this universe. It would even be such a nuisance even to the data subjects. So what the Data Protection Act has done, it's provided other reasons which you can rely on, apart from consent. But consent, as I said, is so black and white, and that's why many people, where they can, rely on consent. You get consent and you're good, right? But there are other reasons. One is what we call legitimate interest. Legitimate interest just means that it's important for you running your business. You have a legitimate interest to process this information. I'll give you an example. An employee, let's say even for interview processes, let's not even go employee, for an interview. How are you going to carry out an interview or even consider me without me sending my CV, which has my name, my age, my, things like that? And does it mean you need to send me something beforehand and telling me for the interview, I need you to consent to me, you sending me your CV? No, not really. You have a legitimate interest in that case to receive that information. For your employees in processing the payroll, does it mean you have to send me a consent form that, to process your payroll, we need your name, PIN number, and all that? No, that doesn't happen. Usually you just say, Catherine, give me your PIN number. We need your name to process your payroll. That's called legitimate interest. And so it's usually not a list which you can say that this list of things are legitimate interest, but it's usually for you to consider your business and your business operations and see what you can justify as a legitimate interest, right? Remember, now you can't take everything and you have to segment the data that you collect and you say, hey, yeah, this one, we need consent. This one, let's rely on legitimate interest. Then there's contract performance. Contract performance because, for instance, if I come as a patient, you're my doctor, and I come and I'm your patient, you won't show like that relationship between me and you will be one of a contract where I've asked you, doctor, can you, ABCD, ABCD. And in that context, you can rely on, I collected this information from Catherine because we were in the context of a contract. She's my patient and I'm her doctor and she's contracted me to do ABCD. Right? So there's some data that I'll give you that you'll say, this one, I needed this information for contract performance. Then there's what we call public interest. So public interest is really, it's usually relied on by public bodies. So they will usually rely on public interest. That one, don't pay attention because it hardly applies for your context. The other one is vital interest. Vital interest is usually very applicable for the medical industry and the health industry. It's because it's mostly applicable in cases of emergency. A doctor will never, or should never, or a health facility should never, because a patient has been brought in, you say, because we don't have consent, that now we can't process this person's ABCD. No. Usually most health facilities, in cases of emergency, rely on this particular reason as a lawful reason to process a patient's or a data subject's personal information. The other one is fulfilling a legal obligation. This one is usually mostly used for when you're interfacing with government agencies or law enforcement agencies. I'll give you an example. If you're served with a court order to provide information relating to Catherine Kariuki, you will give it. And when you will give it, you will use this as a justification that you are fulfilling a legal obligation. You know, it can be policeman, it can be something subject of an investigation. You will release it. But remember, again, how you mitigate is you ask for a court order. So not everybody who comes and says, I'm a policeman and I need this, you will tell them, go bring me a court order. I have no problem, but go bring me a court order. I hope at least you've understood those concepts. What this act does and why this act affects you and why you're here for this webinar today is because it has placed in our data subjects' hands certain rights. These rights now, what they end up doing is they form obligations on you. So for every right that a data subject has, there is an obligation on whoever now is handling their data or collecting their data or processing their data, right? So the first right, they have a right to be informed. And you'll notice that this right, they are very connected to those principles that we did, you know. So they have a right to be informed of the use of their data. You know, what we said is why the data is collected, by whom, why. So what most guys do is they do this through what we call a privacy policy. You've seen those privacy policies that people share all the time. That one is the one that tells the data subject what will do with your data. They also have a right to access their data and able to see their data. This just means that me as a patient, Catherine, I can write to you and I'm like, Dr. X, I need to see what data that you hold that is mine. Of course, now what happens to you is you have to verify that indeed I'm the one who is writing to you. Yeah, and all those other things, which, so again, it comes with such yet you cannot deny me. You cannot say that we won't give you this data, Catherine. No, I'll say, Dr. X, I have a right under the Data Protection Act, and I need you to provide this information that you have, which is mine. Okay? Then they have a right to object or restrict to processing of their personal data. So I can tell you, Dr. X, I know you hold my data, and I need you to stop processing my data in any form. Yeah? This is usually mostly in financial institutions are the ones that I see mostly people object to restrict the processing of their personal data, especially in sectors where people aggregate data, you know, in the back end and all these kind of things. I rarely see it in the health sector a lot. But then the other one is rectification or correction or deletion of misleading and inaccurate data. I've just explained this when you were talking about the Googles and the internet, what is available in the internet. Then they have a right of erasure or false or misleading data. So if you hold data which is erroneous, I have a right to write to you and tell you, you need to correct the data. What you have is misleading, as far as I'm concerned. They have the right to data portability in a format, in a format that's reasonable. What this means, and this is very important for the health sector, that I can write to you and tell you, Dr. X, I need you to send the information to me, or I need to send this information that you hold about me, including the diagnosis and everything, to Dr. Y, because I'm moving now to Dr. Y as my primary doctor, and you need to send this information to Dr. Y. Your patients have this right, and the data subjects have this right, yeah? So this is very important for you to know, and it helps if you can think beforehand that, okay, if they ask us to send, in what format will we be sending, within how long? And the catch is, these rights, they're usually time-bound, unfortunately. Some of them are 7 days, some of them are longer, some of them are 30 days. And if you don't do it within that period, that person runs to ODPC and just now becomes a nuisance to you and your practice. They also have the consent to withdraw. They have the right to withdraw consent at any point. Of course, the same way, if I gave you consent, it should come with the right to withdraw it. So always have that in mind. As I mentioned earlier, the data controller has a role, the data processor has a role, and then there is a DPO I mentioned. So the primary one would be the data controller. The Act puts in a lot of responsibility on the data controller, understandably so, because they're the ones who collect, they're the ones who dictate how the data will be collected and used. At the same time, it expects the processor to keep the controller informed, and it has some rules as well if you're a processor. A DPO just means a data protection officer. What happens is you get a centralized person, because remember, data is flowing everywhere within every role in the organization. So you just get a centralized person, and then this person is the one who coordinates anything to do with data or data protection or things like that. Some people, especially huge facilities, outsource this role or hire someone whose role is only this. But for small organizations, such as solo practitioners and things like that, you just get someone with the organization who is designated as a DPO. I talked about data breaches. What it happens is it comes with requirements. The Act, again, remember, doesn't punish everybody who suffers a data breach. The people it punishes is if you're negligent or reckless, and if you don't report. There are some obligations that you have, like if you become aware of a data breach, just notify the ODPC, and the ODPC would usually give you directions on what you should do next, or it just says, okay, with the mitigation measures you've given us, that should be okay. Some data breaches, in fact, will just require you to record. So it depends with the threshold. Some of them you just record, some of them you report, and some of them you're actually required to notify the data subject. I had mentioned earlier about weighing the risk, and some risks like impersonation of data or fraud or things like that, you're expected to notify the data subject. I mentioned about transfer of data before and told you that, especially in the health sector and the financial services sector, there's a threshold that you have to meet before you transfer data, and a simple email can be considered as transfer of data, right? Penalties, you need to know about these penalties. Currently, the maximum penalty is up to 5 million. Or up to 1% of the annual turnover, whichever is lower. There was a proposal placed in Parliament where they were proposing to change this last bit of whichever is higher. That hasn't been effected. And then from the ODPC side, what we've been seeing, they've been dishing penalties lower than $1 million. Mostly they play around 250,000, 500,000, but still you can imagine the reputational risk. It's quite high. A data subject is also entitled to compensation for damage. So especially if they're the ones who go and report you and file a complaint, if they can show the loss that they got, then you can be fined. Then given that, you have to think about the potential pitfalls, especially in the context of what you do as medical practitioners. For instance, there's the issue of consent and patient data handling. How do you store your data, and your security? How is your security in that office of yours or organization of yours? That laptop that you take everywhere. What are the security measures that are put in place? That office of yours, when you leave, who is able to access it? Who is able to access your computer? Do you have passwords? Do you, that office that has files, who accesses it? Are they able to read everything? Can they, if someone compromised or if someone broke in, what would they make away with? Data sharing with third parties. How do you share patient information? Do you just, sambaza on WhatsApp or email or SMS without even any security measures? Even if a patient wanted something, do you share it on SMS, or do you consider the fact, do you have verification measures? Because remember, sometimes someone can be hacked on WhatsApp and then they ask you for something and then you send it. Turns out you've sent it to a fraudster and the rest is history. What are the measures that you have in place on circulating patient data? And, do you allow non-medical staff and restricted access, cybersecurity and hacking risks? There's what I've mentioned about IT, data retention and deletion mistakes. Do you hold your old medical records indefinitely? Do you have a data disposal policy? Because remember, the more data you hold, the higher the risk, yeah? you'd even rather, after a while, you archive. And then now, so that if anything was accessed, it's not everything, but partial access. Then there's the privacy breaches, which we've talked about, and unauthorized access. These are the measures that we've talked about: consent and data handling, secure data storage, safe data sharing, cybersecurity measures. In this day and age, there's so many things that you can do in the cybersecurity context that can really secure the data that you hold. Avoid privacy breaches. And just as we wind up, then I'm sure you're wondering, how does this all come together? Because it sounds very basic and not technical. But how does it come together in any way? And as far as ODPC registration is concerned, because I know that you've been asked as facilities or as practitioners to register with the Office of the Data Protection Commissioner. So how does this all come together? So usually you're expected to conduct a lot of awareness and training. Every person is a weak link. Every person in your office is a weak link and can be the weakest link. Sometimes it's just your receptionist who verbally will open a file and read out certain private information to someone else or give them access. You've heard of situations, like I know there's a situation in Kenya where someone took a photo of, it was a hotel. So they took a photo of the list of guests and guest rooms. And they just wanted information about one person, but what they took was a whole page. And that whole page ended up circulating on social media. And obviously the hotel got into problems with ODPC. In that case, it was just one person who was probably, I don't know, the room's manager or even a staff there. But why did they have access to the entire list is what they'd be asked. Why didn't they have limitation, and did they need to have that? So it's such things that you need to identify. I said you need to identify who is the central person that you'll have, who will be your data protection person in the office. How do you have documentation surrounding all the processing activities? I know this might be a bit technical, especially if you're not a data protection practitioner or an IT practitioner and you're not a lawyer. It gets very hard to understand, okay, what documentation do I need so that I can file it at ODPC? And then ODPC can indeed say that I'm compliant. And that's where we come in, and then we draft the information for practitioners. And so that you're able to file and stay compliant. That said, I always like to bring in something small, like a case study, to just figure out whether my people have understood or whether we need to do another lesson another time, just repeating it, or next time do we move to 2.0, which is now the next phase. And this is a case study. With your permission, I'd really like you to read the case study, and I'd love to hear what people would like to say about this and whether they've understood the concept. This helps me usually understand whether they've understood the concept. And I don't know if you can see it on your screen. So there's this clinic called Sunrise Clinic, and it's a leading private healthcare facility that treats thousands of patients annually. So it uses an electronic health record system to store and manage patient data, including medical history, lab results, and prescriptions. So one day, a hospital administrator receives an urgent email appearing from the hospital's IT department. This email requested login credentials to update a EHR system. But without verifying the source, the administrator entered her credentials into the link provided. Within hours, if not minutes, unauthorized individuals gained access to the patient records, including names, addresses, phone numbers, diagnosis details, lab results, and prescriptions, insurance and payment information. The hospital only discovered the breach after patients reported suspicious calls from individuals claiming to be hospital representatives offering fake medical tests. IT security experts determined that it was a phishing attack, where hackers tricked an employee into giving access. Over 5,000 patient records were compromised. The hospital was fined by the Data Protection Authority for failing to have strong security measures in place. Patients lost trust in the hospital, leading to a decline in patient visits. A lawsuit was filed by affected patients, leading to financial and reputational damage. What I'd like you to tell me, my listeners, is what mistakes did the hospital make? How could this breach have been prevented? What measures should be in place to protect patient data? And how should the hospital respond to regain patient trust? Maybe we can start with the first one. What mistakes do you think the hospital made? I don't know if you guys have access to, you can just type in, or I don't know if you have access to be able to talk.
Peter, are we able to unmute once hands are raised? So we have some comments coming in. I see Sarah says that lack of training on the common cyber attacks.
Correct, Sarah.
And
Yes.
giving an external person
Person
access.
access. Mm-hmm. Yes.
Peter, are we able to have some people unmuted? Is it possible?
Yes, Joseph, they didn't report to the ODPC, to the regulator, right? Inability to verify the authenticity of the email, correct, Brian? Lack of awareness of external phishing attacks, correct, which means they hadn't done awareness and training to their staff. No restriction of access to information, correct. They hadn't put in measures on who can access and who can't access. Yes, the hospital did not report to the patients of the breach, correct? Because after they had done an assessment, they should have figured out, is this one of those we should tell our patients because they face the risk of fraud, which actually really happened. It would possibly have admin rights. Oh, IT would possibly have admin rights. Yes, Sarah. There should be very limited access rights. No access logs. Yes, they would have figured out if they did an audit, they would have figured out who would have logged in or not. And also access, yes, Elvis, access is an issue. Should be limited access. Lack of, yes, James, lack of SOPs on how to share classified data. Yes, because had they done training and had SOPs, then they would know that when you ask for certain data, these are the procedures that you follow before sharing such data. Verification, and remember what we said, part of it would be verification. In what format is it shared? It would probably be anonymized. Maybe the patient would even be told, we only share in the email address that we have within our records and things like that. Just verification. Lack of data protection expertise. You're right, Martha. I believe the lack of EDR security and phishing awareness training. Yes. Training is, people underestimate training, but as we said, people are your weakest link. So you can have all these measures in place, but if your employees are not aware, because it can come from different angles and different areas, then if your people are not aware to notice and flag, not only notice, but flag, yeah, and when to kick off the incident response mechanism that you put in place, or SOPs as someone else mentioned, then it's an issue. Training on cybersecurity and phishing, yes, Caleb. The hospital email may not be configured correctly to mark phishing. Yes, like just technical safeguards. We call them technical safeguards, where your IT team would be, because remember also IT, because of cyber criminals keep evolving, and therefore your IT safeguards should also keep evolving with what is happening, and they should keep getting better and better. Training on cybersecurity and phishing, yes, Caleb. There should be a verifiable ways, including quality assurance, to avoid cyber crimes. Yes, Kevin, that's correct. there should be consistent OJTs to remind one another. John, what's OJTs? Maybe you can tell me what OJTs are. Then Dr. Brenda, okay, yeah. Okay, we can go to the Q&A. All right, so Dr. Brenda, let me just access the Q&A.
So maybe let me assist
Okay.
you. Richard asks, yes, Richard, I think Catherine spoke about the rights of the data subject. Richard is asking, does a person have a right not to give sensitive information, or is it a must? I think that was kind of answered in your presentation, but you can go through that. Then an anonymous attendee asks, what are the obligations of the data collector to government agencies? So an example is CCTV surveillance may pick a breach of the law within or outside my premises. So what liability do I carry should I delete that data that is immediately or within the scope of my organization's retention period, only for the police to find a gap in continuity, yet the deleted part could have been crucial evidence to prosecute the case. So I think you can take those two.
Okay, so I can take those two. I think the first one was on sensitive data. What obligation do people have? Remember, I'll take you back to when we did reasons or justifications for you to collect someone else's sensitive data. There was one which I'd like to remind you guys that I flagged. Let me just, oops, I think I closed my, but there were very reasons. And remember when I told you consent is not the only justification. Yeah. When it comes to sensitive data, you can rely on many reasons. There's this particular one that I want to remind you. Yeah. There are many reasons why you can process someone's data. Remember the one I said, vital interests. Vital interest is usually in the case of an emergency. It usually applies very well for health practitioners. So that in the case of an emergency that you don't need to get, but in other cases, you need consent. You need consent or these other reasons. And that takes me to the second question, which someone has asked about government agencies and justification. So you have no obligation to, let me say, the law would have to compel you, and there's no law that compels people that if you come across, unfortunately, which, I mean, this is a difference between our law and ethics. So I'm talking strictly as a lawyer, that if you witnessed someone being hit on the roadside or assaulted on the roadside, that if you don't report it, it's a crime. So that's the same concept like the question that you've asked. So there's really, unless, again, you are part of the crime and things like that and cover up, which I'm assuming this is a case of you put CCTV cameras to enhance your security measures, and then find there was what happened, and then later on when the cops come, they find that you deleted, and it was a malicious deletion, like you deleted whatever was there. No, you won't get into problems legally. If it answers your questions, if not, ask me to clarify, just clarify and ask me. Dr. Brenda, is there another question? Is that
sorry,
it?
I was speaking while muted.
Okay, sorry.
Yeah, so we have 8 more questions on the queue. I think we'll just go through them quickly. Does the law define the storage limitation for different industries? I think maybe that would be a yes or a no. Then what are the qualifications of a DPO? So in terms of storage limitations for different industries, and do DPOs have specific qualifications?
Okay, fine. Does the law? No, not strictly so. It's not the law that does that, but usually for organizations or professions that have professional bodies, I'll give you an example, like us lawyers, you'll find that within the professional body will give a guideline of, like, for lawyers, you can keep your client records for up to 10 years. Maybe for doctors, I don't know about you doctors, whether your professional organization has provided that, a guidance on you, but there are some things that are strictly provided by the law. Employment, as I said, tax, like your accountant knows how long they can keep tax records, which I think is 7 years, or things like that. But for these other things, bodies now, especially bodies that self-regulate, they usually have guidance for their people. On the issue of the DPO, if you're big, and I'm talking now my hospitals, my huge organizations, like now my banks and things like that. So I usually advise for them to have an in-house DPO. And this in-house DPO usually has, their qualifications is that on top of what they've done what we call courses, or they've practiced within the space. Like I have practiced myself, like now me, I would easily cross over and be a DPO of an organization because I practiced in this space for so long and I'm aware of the practical insights or practically how to go about it. So usually these DPOs will be a certified data protection officer. It just means that they'll have done some courses, like for courses offered by Privacy International or privacy organizations, and they'll go and work for those organizations. For my small people, what I usually tell them is you don't need to add someone else on your payroll. It doesn't make sense because also I'm thinking the data that you handle you're not data heavy, and therefore you don't need someone who this is a sole JD. What you do is you take that one person and you tell them this is your you'll be our DPO, our internal DPO, on top of what they do. And then you take them for courses. So for instance, you pay them for a course to be certified as a data protection officer and things like that, to attend trainings here and there. Over time, they become actually really good. And why you need a designated person is so that also they have a history and understanding of the business or the data flows within the business. So if someone asked them, they would be able to easily explain it, because also that ODPC office usually comes with many questions here and there. So you need that centralized person to be that DPO. But then in some instances, especially where the organization is small, even you can be the DPO in the beginning. And then over time, as you grow, you can now move it to someone else. The other thing that people do is initially you can outsource DPO services. So like part of what we do at Africa Privacy and Legal, we act as DPOs for certain organizations. And then what usually that happens is that we now help with compliance, and then any queries that come that are related to data, we act as your data protection officer, but outsourced. And that just saves on cost, because you see, we'll act as a data protection officer for many organizations, which means the cost will be a bit lower for you, so that you don't take on the responsibility of like a full-time DPO. But there's the mandatory requirement of a DPO under the Data Protection Act is when it's data heavy or big organizations. So I want you to think organizations that have 50 people and above, handle sensitive data. As I said, health institutions, hospitals, and financial institutions. But if you're small, no, it's not. Don't think of it as one of those things that you have to take on like immediately.
Okay. So thanks, Catherine. I think we'll just take 2 more questions because of time, and then we can close. So number 1 from Mike is, are there circumstances where disclosure of data supersedes the doctrine of confidentiality? And if there are, please give examples. And then I've seen another one, which I think is important. So does the justification by third parties, that is insurance providers and administrators, of legitimate interest or contract performance override the right to health and privacy, especially sensitive diagnosis for patients? And must doctors share this information with the third parties? I think this is a real, dilemma. So if you can take those 2 questions, I think we'll be able to close.
Okay. So on the first one, sorry, Dr. Brenda, repeat the first one. On
So
when?
are there circumstances where disclosure of data supersedes the doctrine of confidentiality, or rather the principle of confidentiality?
Very, 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 very rarely. Like it's the exception rather than the rule. And there are instances where you would be, again, I go back to my reasons for sharing. The instances where you can share the personal data, but you expected, again, everything in this act comes with a cut. That even when you share, you're supposed to have in mind the principle of minimization, the principle of this. So for instance, instances where legal obligations, you've gotten a court order, right? You've gotten a court order that you need to share this in this. Cops, again, are in the process of an investigation and again have gone to court and they've come with a court order. You see, that overrides the principle of like confidentiality, strictly technically thinking. I had mentioned about emergency, vital interest, that you have a justification for vital interest. So vital interest is, for example, where I, as Catherine, I'm in an accident and I know that it's, and they know that it's Dr. Brenda who was treating me, and Dr. Brenda has my records regarding ABCD. I'm unconscious as Catherine. Am I going to be looked for to give consent, or for my next of kin to give consent? Or again, are they going to attend to me? And Dr. Brenda, is Dr. Brenda allowed to share with those people that my blood group is whatever, B group B or whatever? That is usually called vital interest. So there are those exceptional cases where it overrides that. Very exceptional, but you have to be aware. On the second one, for
The third
legitimate,
parties we deal with, yeah, like
sorry?
the insurance. Does the justification by third parties, that is insurance providers and administrators, of legitimate interest or contract performance override the right to health and privacy, especially sensitive diagnosis for patients? Because now there are third parties
Absolutely,
involved in this, yes.
absolutely not. Absolutely not. And there are considerations that will be so. Legitimate interest, I want you to think of it as a hierarchy of sorts. These reasons kind of have a hierarchy of sorts. So legitimate interest, remember I told you, is more business savvy angled. Like most guys rely on it for like businessy, and therefore it can never override the fundamental rights and to privacy when it comes to your health records and things like that. Never. So usually also businesses use it very carefully and for very what I'd call minimal, because again, remember they always consider the right to your fundamental rights and freedoms, the risk to your fundamental rights and freedoms for a reason to be justifiable. And it's very hard to weigh legitimate interest against the risk to fundamental rights and interest of a patient when it comes to their health records and have legitimate interest win. So I'd need a specific scenario, but I can tell you highly unlikely. Highly unlikely.
Okay. Thank you, Catherine, for that. And I think we'll close. I know there are a lot of questions coming in. However, just look out for the upcoming webinars. I think we'll continue to do this webinar series and just prepare the membership for compliance. So we appreciate the facilitation. I see a lot of interest in your presentation. If you could share that with us, we'd appreciate it, and we can then transmit it to those who've registered here. Please find this recording on the KMA YouTube page channel, and this will be sent to you on email through the email you registered for this webinar with. Asanteni sana for joining. Thank you very much, Catherine and your team. We look forward to engaging you more, even as we extend this information. Asante sana.
Absolutely. It was such a pleasure, and you had a wonderful audience. At least I know I wasn't talking to myself the whole time, given the understanding that they've demonstrated at the end. And yeah, thanks for having me.
Yeah, thank you very much. Have a good night, everyone, and thank you for making time for this important webinar.
See you.